They cannot both exist. They exclude each other. You either have fraud or you have undue influence. When a person is subjected to fraud, he is led to do something because of the deception, the deceit, and he does it quite willingly. Undue influence, on the other hand, connotes the idea of coercion. The person subjected to undue influence is unable to express and manifest his own will because his will is overpowered by the will of another. So you cannot have both fraud and undue influence, sabi ng Supreme Court. At any rate, sabi ng Supreme Court, the oppositors are faced with a dilemma. If they are opposing the allowance of the original of the will because of the absence of marginal signature of one of the witnesses on page 3, there is no reason why they should also oppose the probate and the allowance of the duplicate original, which after all contains all of the required signatures at all of the appropriate places. Okay? So, sabi ng Supreme Court, it would seem, under the circumstances, that the failure of one of the witnesses, Attorney Natividad, if I remember correctly, to sign on page 3 was simply due to inadvertence, due to the simultaneous lifting of 2 pages. Yun lang ang dahilan kung bakit hindi na pirman yun. Now, if you're asked a problem, 5-page will, page 3 does not have the marginal signature of either one of the witnesses or the testator. Should the will be allowed? I submit that the ruling in Icasiano should be limited only to the precise circumstances which obtained in that case. And the most important thing you have to remember in Icasiano is this. In that case, there was a duplicate original. There can be no doubt at all in Icasiano that there was a validly executed will because there was that duplicate original. If, on the other hand, you only have one copy of the will, yung original lang, and that single copy lacks one of the required marginal signatures, I submit, following earlier rulings of the Supreme Court, the will should be disallowed. Put another way, the ruling in Icasiano has not done away with the previous rulings of the Supreme Court in many cases where the court invalidated wills because of the absence of the required marginal signatures. Okay? It did not, the ruling in Icasiano did not and should not be interpreted to mean that we can now do away with the requirement for marginal signatures on each and every page as expressly mandated by paragraph 2 of Article 805. So kung isang kopya lang, kulang ng marginal signature, I submit the will should not be allowed. Okay. All of the pages should be numbered correlatively in letters placed on the upper part of each page. The precise location of the numbering is not really essential for validity. In other words, while the law says the numbering should be placed on the upper part of each page, if they place the numbering on the lower part of each page, pwede yun. They place it on the left margin or on the right margin, okay yun, basta may numbering. As long as all of the pages are numbered correlatively in letters, okay? And what is meant by numbering correlatively in letters? Ibig lang sabihin yun, you spell out. So, instead of simply writing the Arabic numeral yung 1, okay, dapat, if you want to follow the provision literally, you write the word 1. Next page, 2. Yan ang correlative numbering in letters. Eh kung tinatamad yung nagdadrap ng dokumento, 1, 2, ang ginamit niya, Arabic. Pwede rin yan. Okay? that will not affect the validity of the will. You can use Arabic numerals, Roman numerals, even letters of the alphabet. Page A, page B, page C, as long as there is correlative numbering. Okay? Now, supposing that it is a 5-page will, pages 2, 3, 4, and 5 are numbered. Page 1 is not numbered. Should the will be allowed? The answer is yes. It should be allowed. Why? Because even if page 1 does not have a numbering, there can be no doubt at all that that is page 1. Nandun yung simula ng will. Last will and testament of so-and-so, etc. No all men by this presence. Okay? And then you look at the next page, it's page 2. So that must be page 1. Okay? So if page 1 is not numbered, but the other pages are numbered correlatively, as required by law, that should not affect the validity of the will. Okay. The witnesses are required to sign, among other things, on the left margin of each and every page of the will. Just like the testator, the witnesses can also sign with their pen names, with their nicknames, with their screen names. Can they sign with their thumb marks? I submit that they can. Okay? As long as, in reality, they know how to read and write. Because one of the requirements for witnesses is that they should know how to read and write. So as long as they are actually literate, they can sign the will with their thumb marks, if they intend that as their signatures. Okay. Would it make any difference if the witnesses signed the will ahead of the testator? Halimbawa, the testator asked the witnesses, "Oh, you sign ahead. Muna na kayong pumirma." And the witnesses signed, including the attestation clause. They all signed. Only after the witnesses had signed did the testator sign the will. Should that be a valid will? I think the better view is that as long as there is no interruption, as long as everyone signed during one single continuous occasion, the will should be valid. Okay? Actually, the thrust of those who believe otherwise is that if the witnesses signed ahead of the testator, they're actually attesting to a falsehood. Because they will be signing in the attestation clause that the foregoing will was, among other things, signed in our presence by the testator. Eh, hindi pa naman nagaganap yun because the testator has not yet signed. Therefore, if they do that, they would have been attesting to a falsehood. But I repeat, I think the better view, I submit the better view. And, of course, this is merely an obiter, but the Supreme Court said so in Cañeda versus Court of Appeals. Although the statement of the court there is clearly an obiter. As long as everyone signed during one single uninterrupted continuous occasion, the will should be considered valid. Okay. If, however, the testator invited the witnesses to his residence on January 1, and he told them, "Oh, this is my last will and testament. I want you to be the witnesses. Would you please sign?" Pirma ang witnesses. After the witnesses had signed, the testator had not yet signed. No? After the witnesses had signed, sabi ng testator, "Let's meet again on January 6. I want to think about this." Sabi niya, kung talagang ito na ang last will ko. And they met on January 6. And it was on that date when the testator signed. I submit that in that case, the will should not be allowed. Because it's clear there that when the witnesses attested the execution of the will, they were attesting to a falsehood. Because the testator had clearly not yet signed as of January 1. As a matter of fact, the testator signed only several days later, January 6. Okay. Next point. If a third person has been asked by the testator to write his name on the will for him, sabi natin, it must be done under the express direction of the testator and in his presence. The mere silence of the testator or his failure to object to the signing by a third person is not the express direction contemplated by law. So, if the testator is very sick, nandiyan siya sa sangkatutak na mga tubo na nakadikit sa kanya, and his lawyer, who had earlier drafted the will in accordance with the instructions of the testator, told the testator, in the presence of the three witnesses, and let's even say, even the notary public was there, sabi ng lawyer, "Oh, Mr. Testator, I don't think you are in a position to sign this will yourself. So, unless you have an objection, I will sign this will for you." The lawyer waited for about a minute or two. And then later on, wala naman sinabing testator, nakatingin lang yung testator. Sabi ng lawyer, oh, wala siyang objection. So, I will sign the will for him. That is not a valid will. Walang express direction. Mere failure to object, mere silence is not express direction. The express direction, however, need not be done verbally. If the lawyer asks the testator, "Mr. Testator, do you want me to sign this will for you?" Sabi ng testator, tumango, he nodded. Okay na yon. Pwede na yon. Ha? That is already an express direction. Okay. It must be done, of course, in the presence of the testator. So, if the testator orders his lawyer, "Oh, attorney, ipirma mo na ang pangalan ko dyan." Ha? "O, sige ho." Okay, and the three witnesses were there. "Oh, si attorney ang pipirma para sa akin dyan." But it was too crowded inside that small hospital room. So the lawyer and the witnesses went to another room. Patay na. That's not a valid will. Because the signing by the third person must be done in the presence of the testator. Supposing that the testator was really very sick. So sabi niya sa lawyer, the three witnesses were already there in the hospital. Sabi niya, "Attorney, I want to make my will." "O sige, anong ilalagay natin?" "O ito," sabi, dinikta. The testator dictated the provisions. Number 1, yung bahay ko sa Alabang kay ganito, yung bahay ko sa Quezon City kay ganito, yung lupa ko sa Bulacan kay ganito. Okay. So the lawyer took notes, and then sabi ng testator, "Attorney, I want you to sign that will which you will be drafting. I want you to sign that for me." Takbo yung lawyer sa kanyang opisina. He encoded the will as dictated by the testator. He rushed back to the hospital carrying the printed will, ready for signature. Pagdating niya doon, the testator was already unconscious. He had already sunk into a coma. Hindi pa naman period. Coma pa lang. Okay.